Welcome to Legal Lines. My name is Tom O'Shea, the host of this program that's brought to you by the York County Bar Foundation. Our topic today is District Justice Court, and my guest is Ronald Haskell, District Magisterial Judge for the City of York.
Yes.
Okay. And I know that when I was introducing you, I stumbled because the proper title now is District Judge, correct?
We are now District Judges.
Okay.
Yes.
At one time, back in the day when I was young, it was called District Justice Court, but I've been corrected that the title's been changed.
Well, do you think your audience would like to know why?
Go ahead.
It was changed a few years ago, maybe about 5 or 6, from justice to judge, and we think in the district court community that the Supreme Court realized that they were the only other people called justices, and they didn't necessarily wish to be associated with us.
They didn't want to share the title.
They didn't want to share the title, so that's what we believe.
Let's talk about District Justice District Court, and exactly what is it?
Well, it's a court of limited jurisdiction. It doesn't involve all areas of law, but just a narrow select 5, I call them 5 areas of law, although there are lots of subsets. And those 5 areas are, of course, civil law, and as a subset of that, or a separate area because the procedures are so different, landlord-tenant law. There's the traffic court aspect of what we do. And then under criminal, there's both your normal criminal misdemeanor felony, but also summary criminal offenses, which are like your public drunkenness and your harassment cases. And they involve, on the summary non-traffic side, a lot of different things. Also, dog law is included, game law enforcement is included in that, building code enforcement. So there are a number of subsets even within that subset.
Now, in York County, how many district courts are there?
There are 19 district courts.
And each broken into a geographic district?
Exactly.
And the City of York has
4.
And you cover the south end of the city?
Basically the south end of the city, from the square, going south on George and Duke Streets. And as we get to the old post office, my jurisdiction swings to the west till about Pershing Avenue, working itself then up to the Springettsbury Avenue right at the college, and across Springettsbury to George again, then out to Rathton Road, and around Rathton over to Edgar, up around near York Catholic, but not York Catholic.
Okay.
And then back over to Duke and back over to Market.
And within that district, you would handle, let's talk about the 5 areas. The first one you mentioned was civil, but it would be civil claims that would be under a certain dollar amount? Yeah,
the jurisdictional limit for this district courts is now $12,000. And something that people don't know about is if you have a claim for $12,000 or $13,000 or $14,000 or $15,000, the procedures at our level are a lot more simplified. You can do it without an attorney. And if you're willing to accept a judgment of only $12,000 and you have a claim for $15,000, you could conceivably press your claim at the district court level and accept a judgment for $12,000 as opposed to a judgment for $15,000.
Okay, so if I would use the simple terminology, we could call it like small claims court?
Exactly, yeah.
And small claim, by definition, by the state now, is under $12,000, which is a significant amount of money.
Still quite a valuable claim.
So if somebody has a civil cause of action against another company or an individual, they can go to district court. Yes. And not have to hire an attorney and not have to file very formal pleadings?
Exactly. The pleadings it's a 1-page pleading. You state the amount of the claim, the basis for the claim, and where it arose from, whether it might have been a car accident or a contract claim or work that a contractor did at your home that was insufficient or led to other damage. You just write it in a simple paragraph form, and that's sufficient enough to start the process.
And you mentioned that somebody who had a claim for, let's say, $13,000 or $14,000 may choose to go to your court to press for only $12,000. And the first thing a person might ask is, well, if I'm owed $13,000, why would I ask for only $12,000? And your answer would be?
You're not having to hire an attorney. You're not going to pay all of those costs. You're going to have a hearing in my office in about 3 to 5 weeks, whereas if you had to go to the Court of Common Pleas and file a formal complaint, you tell me, Mr. O'Shea, how long would that civil claim take until it saw the light of day?
I don't want to speak for the court, but I would say that
it's not a few weeks or a month or two.
It's not a few weeks. If you're lucky, it will be before a year.
And the other thing, too, when people have small claims, there's two sides to every claim. And, you might think that your claim is worth $15,000. You might agree to go to the district court level and press it forward. And things might come up, things brought up by the other side or things brought up by the court that may make you realize, you know what, this was only a $7,000 or $8,000 or $9,000 claim, and I understand that now. And you buy into the judgment then. So that's one of the other benefits of it.
I also want to point out before we move on that you are an attorney.
Yes.
Okay, but not all district judges are.
Correct.
Okay, there isn't a requirement that a district judge have gone to law school.
No, there isn't.
Okay.
Those judges who aren't legally trained, though, do have to go and attend a month-long education program in Harrisburg and pass a pretty rigorous test in order to be allowed to sit and adjudicate cases.
Okay. So when you broke down civil into the component of a regular civil lawsuit over money, but then you mentioned that there's another area that I would think of as a civil cases, which would be landlord-tenant.
Yes.
And there are different rules for landlord-tenant cases.
Yeah, there's very specific rules about filing and hearing requirements and notice requirements. So it's a little bit more complicated than your straightforward small claim civil claim. You can make mistakes in the landlord-tenant realm and, really undermine your own case if you as a landlord aren't up on what the requirements are. So I tend to think of it as a separate area of law because you need a separate knowledge base to press that claim forward. And many lawyers are not well versed in what that knowledge base is. So I like to point out, and you and I have discussed, that one of the things that is occurring in the world today is that we are becoming a populace that needs to educate ourselves on self-education, autodidactic, I guess is the right term. And the York County court system has created a self-help center at the Judicial Center, and they are well versed. The lady who runs the program, Megan Dietz, in the civil law and the landlord-tenant law, and that if you wanted to look into proceeding in a civil case at a district court level, they can provide you some resources. And additionally, if you are being sued as a tenant, they and legal aid provide lots of flyers and information on how you prepare yourself for the hearing, what proof you might need, and what your other rights are in both the civil and landlord-tenant cases.
Okay, you're pointing out something very important for viewers, and that is that there's a self-help center at the main courthouse, the Judicial Center in downtown York. I believe it's on the 4th floor. And so before you would go necessarily to file a case at district court, you could basically
get some free
help ahead of time.
Yes.
The people who work there are not attorneys. They cannot give legal advice, but they can lead you in the right direction to get the forms you may need.
Yep.
And while I'm talking about this, since we're both attorneys, I need to plug attorneys. At district court, you can have an attorney.
Yeah, absolutely.
You're not like prohibited from bringing an attorney with you.
Correct.
Okay, or having an attorney fill out the paperwork for you.
Mm-hmm.
You can do so yourself, even though, or you can do that with the help of an attorney.
They tend to get in my way, but they're allowed in.
They're allowed in. That's nice. But you basically, we take the position in Pennsylvania that you have the constitutional right to counsel, and if you want to bring an attorney to district court, you can. I believe in other states they take the position that if it's a small claims matter, that the parties aren't being represented.
Yeah.
It varies from state to state, is what I understand. But nevertheless, so just you can have an attorney at district
absolutely.
court.
And there are landlords. I had a landlord today who came in with able counsel, a guy that we both know, Mark Roberts, who knows landlord-tenant law, and I like it when I see either Mr. Mitten from Legal Aid or one of the more knowledgeable attorneys in landlord-tenant cases, because I know that we're going to get right to the meat of the facts and not be bogged down on a bunch of side issues.
Because Pennsylvania has a very strict landlord-tenant law with various rules that have to be followed. And most lawyers, like myself, have no idea what that says. It's a complicated law. At least,
it's not that.
For people who don't deal with it, they might find it has different rules than other areas of law.
Yeah.
And so if you're dealing with it all the time, which I'm sure you are, and the attorneys that you mentioned deal with it quite frequently. And by the way, the landlord-tenant provisions, either side can be the moving party, the plaintiff. The landlord.
The landlord. Pardon me. The landlord would always initiate the process. The tenant couldn't sue to compel the landlord to do anything. The tenant's cause of action, you could say, is to just not pay the rent. And landlord-tenant law in Pennsylvania says that if you as the tenant have notified the landlord of a breach of the warranties of habitability, and the landlord hasn't remedied it within a normal time frame, you have the right to take your rent money and place it in escrow in a bank account. And there's a specific type of bank account you would put it into at the bank.
So the burden is completely on the landlord.
Yeah.
If the tenant believes that the landlord isn't providing proper service, they're not allowed to just say, "I'm not paying my rent," although some
quite a number do.
But there is a proper procedure for the tenant to take what would be the rent, put it into some type of escrow, and say, "I'm not going to give it to the landlord until the landlord remedies what the problem is."
It's the old, "Here is the carrot, I'm very happy to pay it to you, but you know what, I'd like that front door to lock securely before I pay my rent, because I've asked you 3 months in a row to make sure that door shuts right."
But on the other hand, if the landlord comes into your court because the rent isn't being paid, there are certain procedural safeguards that apply to the tenant.
Yes.
And the tenant could have a defense that the landlord didn't do something the landlord was supposed to do, which could change the amount that the landlord is entitled to be compensated?
Yes, and it's kind of fact-specific to try to get into, but conceivably, if the landlord did not realize they had a duty to make a certain repair and didn't make the repair, and the tenant had asked for it to be addressed, then the fact that here, I thought of a good example. In a single dwelling home, if the lease were to say any infestation, termites, cockroaches, ants, bed bugs, or whatever, is the responsibility of the tenant. In a single family dwelling, it would be the tenant's responsibility after they move in if there's an infestation to fix it. However, if the property being rented is a multi-unit, if there are 2 or 3 apartments, well, you could put what you want in the lease, but the reality is if you only clean 1 apartment, the bugs go to the other 2 apartments and then they come back. So you can put it in a lease, but the landlord may come in and say, I don't have to fix the infestation issue. It's in my lease that it's the tenant's responsibility, and I would ask, is this a multi-unit that you're renting? And they'd say yes, and I'd say you can't place that burden on the tenant. It's yours because the landlord is the one that can control the whole building. That would be one of the issues you would deal with. And by the way, we're going to end this segment. We'll be back in a few moments.
Welcome back to Legal Lines. Our guest is District Court Judge Ronald Haskell, and we are talking about district court. In the first segment, we talked about the civil aspects that are handled at district court, civil cases under $12,000 involved in controversy, as well as landlord-tenant cases. But district court also deals with various criminal cases, and one area which is quasi-criminal is traffic violations. So
Right.
let's talk about that. How does district court get involved with traffic citations?
You know, overall, besides just talking about traffic, the distinction between district courts and the Court of Common Pleas is that most of the hearings at the Court of Common Pleas, or many, will have juries at them. And at the district court level, it's the judge, both the fact finder and the lawgiver, and that imposes punishment without the benefit of the probation department. So in traffic cases, I'm hearing everything from a parking ticket to driving under suspension with multiple violations and driving while DUI suspended. And those fines can run the gamut from $0 or $5 up to $1,000. Some traffic offenses can have fines of $2,500, and some of them involving tractor-trailer violations have a whole separate fine structure to them that is a show unto itself and will surely put your viewership to sleep.
Okay.
It's a good 1 a.m. show, I would think.
All right. But basically, if someone just, let's say, a simple speeding ticket, they're cited by the police for speeding, and they're given a choice, as I understand it, when they get the citation, of either paying the fine and pleading guilty or pleading not guilty and having a hearing.
Correct. Yes.
And that hearing would be before you, before your court.
Exactly. Yep. The parties would come in. I'd swear I usually ask, is there any way to resolve this thing in case the defendant has talked to the officer and there may be a solution out there. I always ask that first, and if there's not going to be a solution, we'll proceed, swear the officer in. I'll hear his side of it, ask the defendant, and if the officer has any witnesses, we'd of course call them up, have them testify, provide the defendant or the defendant's attorney the opportunity to cross-examine any witnesses who testifies against the defendant, and then the defendant can call witnesses and then testify themselves on the matter. The court may then ask questions and either suggest a solution or find a person guilty or not guilty. I think one of the funniest things, and people may not believe this at first, but people have always said it must be really hard doing a criminal case when it's a homicide preliminary hearing. And I've told them no. And the reason why is you've got the best detectives working the case, and you've got the DA's office with their best folks on it. And, those cases are presented and they're airtight. Usually not a hard decision to make. It's the stop sign violation, where you get the officer who testifies to what they've seen, and the defendant says, I feel really bad having pled not guilty. I have a lot of respect for the police. I really believe that at that time I came to a full stop and this, that, and the other thing. And I remember that because I remember seeing some people down the block, and I didn't know how close they were to the intersection before I proceeded. And you're just the three of you in the courtroom. That case can cause me to pull out more hair than sometimes a homicide case.
It all turns on who you believe.
Yeah, and sometimes folks are very compelling, and sometimes you make the decision. That decision can be harder at times than you'd think.
Well, you brought up something else that we were going to segue into a little later, but let's deal with it now.
Okay.
And that there's a component of criminal cases that is handled at district court level.
Yes.
And you picked a homicide case, but so serious crimes go through the district court level first.
Yes, but I'm not reaching a final adjudication on those cases. I'm just holding the preliminary hearing and making sure there's enough evidence to send it to court for a trial by jury. And one of the things that I don't think the public appreciates enough, and I don't think enough people appreciate enough, even within the legal or law enforcement community, sometimes you'll see a case go to trial at the Court of Common Pleas, and there may be a guilty finding, but the person isn't found guilty of the most serious offenses. And I personally think that's because the case has not been prepared as it should be. And it could very well go back to an MDJ, a district court judge who hasn't done their job fully. Because I think if you do your job fully and don't just rubber stamp cases, then the juries are going to hear stronger cases than otherwise. And the way I have explained this when I've talked to other groups is if the DA presents 5 pieces of evidence and there's not quite enough to be sure that there's a solid case against the defendant, a district court judge ought to dismiss it. Why? Because the Commonwealth, if it gets a 6th piece of evidence, can then refile that case against the district court judge. And if it isn't compelling at that point in time, the district court judge can dismiss it again. Commonwealth can refile. Now there are 7 pieces of evidence. If the district court judge is satisfied and binds that case over, you know what? That case in front of a jury with those 7 pieces of evidence is probably going to be stronger than that case with only 5. And you're going to get, I think, stronger, better results from jury verdicts when you are faithful to the responsibility of what you're trying to adjudicate at the preliminary hearing.
And let's break it down. The preliminary hearing, what is the purpose of a preliminary hearing?
It's to establish, number one, that a crime's been committed that it's more likely than not that the defendant committed the offense. If the defendant, I always say to them, if you have a defense, it's not heard by me, it's heard by 12 jurors. If you're golfing with the president and you have photos, you cannot present them to me because that issue gets presented to the jury as to whether or not they want to believe that you were golfing with the president that day.
So basically, in a criminal case for any type of crime, but for serious, very serious crimes, it still goes through the district court level for the district judge to make the decision whether or not the prosecuting office or the police officers or the DA's office has enough evidence to at least establish that there's a likelihood that a crime occurred.
Exactly. And in the legal community, in Latin, we call it a prima facie case.
And so it would be your job to determine whether or not the prosecuting office has established the prima facie case.
Exactly.
And it doesn't matter whether the defendant has a defense that might
excuse, explanation, defense.
That's up.
That's for 12 jurors.
To the jury, which goes further at the Court of Common Pleas.
Mm-hmm.
But all that you're doing right then is passing the case on to the Court of Common Pleas.
Exactly.
Okay, but in addition to that, prior to the involvement of a preliminary hearing, there are things that your court does as well. For example, search warrants, arrest warrants.
The public should know that most, if not all, criminal cases originate at the district court level. We'll issue the search warrants. We'll issue the initial arrest warrants. We'll hold the bail hearing when the person is arrested on the charge. We'll determine whether or not the person gets released and whether they get released with specific conditions. And then we'll schedule the preliminary hearing. And we're on the forefront of criminal law, and then the adjudication is on the back half of the system at the Court of Common Pleas.
This is all done before it ever really gets to the Court of Common Pleas, where ultimately a jury will be called and the case will be decided. Or a plea resolved. Or a plea would resolve the case, or however the case is finally resolved. But everything is the lead up that goes through the district court.
Exactly, yeah. Okay. And we were talking earlier, my personal interest in trying to resolve criminal cases at the district court level, because certain ungraded misdemeanors and misdemeanors of the 3rd degree, people can enter guilty pleas at the district court level and avoid the need to have it go to the Court of Common Pleas, and we have the same sentencing authority as the Court of Common Pleas judge would have. And I use that to place people on probation and assign them fines and court costs to be paid, which is exactly what they'd get at the Court of Common Pleas. but it happens in much more quicker fashion.
The resolution could come much quicker than going through the Court of Common Pleas, which could take months.
And the reason for that, and we were discussing this off camera, any studies that have been done show that the greatest impact on whether a defendant will reoffend, or one of the big impacts, is how quickly they're held accountable for the offense. So if within a month or two of an offense, a defendant is before me, pleads guilty, takes responsibility, and is given a penalty, that has a stronger impact on them even than instead if the case went on and dragged to 8, 10, 12, or 14 months later at the Court of Common Pleas. To have the same impact, you actually have to sentence the person more harshly, because there's a disconnect between the wrong conduct and the punishment. And you get the punishment and the conduct closer together, has a greater impact on recidivism and keeping people from reoffending.
Now, we were talking here about all criminal cases, but there's certain type of minor criminal case where it's handled almost exclusively at district court level?
Yes, and that's the non-traffic areas of law, the public drunkenness, the underage drinking, dog law violations, violations of the building code, game law violations, are all violations that are handled at our level, where we will be judge and jury, decide, hold the entire hearing, decide if the person is guilty or not, impose whatever penalties we deem appropriate in a particular case.
Okay, and they're known as summary cases?
Yes.
Okay, so if someone is charged with a summary case, is in my understanding, and I don't do any of this type of work, but it's my understanding it's sort of similar to a traffic citation.
Yeah, exactly.
They get cited, and it's not necessarily they get arrested and go to jail and wait for bail or anything like that. They get cited and told, appear before the district judge. And
the Pennsylvania rules say that on a summary citation, if the person is a resident of the county and the officer can't think of any reason why they wouldn't otherwise show up to court, they're supposed to be cited and released on scene. You don't want to clog the courts down with officers bringing everybody in for every citation, when ultimately, if they're a York County resident or a PA resident, you're going to release them anyway.
Right. So those are the cases that would appear before you. You'd make the adjudication. I know we have very little time left, but just sort of clear, there is a way to appeal what goes on in your court.
And in fact, it's an appeal de novo, which means the whole matter is heard all over again, and any findings and determinations I made are not binding on the Court of Common Pleas.
And we're going to have to end it there because we're almost out of time. Our program today was regarding district court. My guest was District Judge Ronald Haskell, who's a district judge in the city of York. This is Legal Lines. It's brought to you by the York County Bar Foundation. My name is Tom O'Shea, and thank you for watching the show.